Good evening, sir. Welcome.
Good evening, everyone. Good evening, ma'am.
Good evening, sir. Sir, if you permit, shall we start the session?
Absolutely.
Yes, sir. Over to you, Chaitanya.
Yes, am I audible, sir?
Absolutely.
Sir. Good evening, everyone. I, on behalf of Legal Expatriate, would like to welcome you all to the third session of 5-day online course on property litigation. For today's session, we have with us Advocate Nagesh Sood. It is my privilege to introduce Advocate Nagesh Sood, a distinguished lawyer with over 32 years of practice before the Honorable Gujarat High Court, NCLT, DRT, Consumer Commission, and other forums. He has represented leading banks, financial institutions, and private clients in diverse matters of banking, corporate, labor, consumer, and criminal law. He has been associated with landmark public interest litigations, contributed to significant labor law pronouncements, and has over 95 reported judgments to his credit. Alongside his practice, he is a respected academic and keynote speaker, having taught at Nirma University, GLS, Karnavati University, and addressed premier forums such as IIT Bombay and GNLU. He also serves as a trustee and director of Befrienders Worldwide, a UK-based charity working globally for suicide prevention, and has led several mental health awareness initiatives across India. Please join me in warmly welcoming Advocate Nagesh Sood. We all are really honored to have you for today's session, sir.
Thank,
Without further ado, I request you to take the charge of session. Over to you, sir.
thank you very much. It's been indeed a very, very warm introduction, and I'm overwhelmed with the kind words which you have just mentioned about me. So let me start by sharing my screen. Is it visible?
Yes, sir.
All right. So good evening, everyone. And I welcome you all for module 3 of our series on partition matters in property litigation. So in this session, we will delve into both the procedural and substantive aspects of partition suits under Indian law. The focus is to make the subject accessible not only to the students who are the participants, but also the practicing lawyer who are kind of seeking practical strategies for filing these suits in the different courts. So, my aim would be to provide you with clarity, certain practical insights, and strategic approaches to navigate this complex and nuanced area of property law. So, the topics we are going to cover over the course of this session would be the legal framework and jurisdictional considerations, exploring the governing provisions and where to file your suit. Then we'll look into court fee and valuation, which is crucial for determining the financial aspects and forum selection. Then drafting essentials, focusing on crafting effective plaints, written statements, and commissioner applications. We'll also discuss the parties to the suit who can be impleaded as parties, including adding or deleting parties, and also handling counterclaims. Then we'll examine decree, what are the preliminary decrees, what are the final decrees, and how we can address the mean profits. Then also, lastly, we will explore the practice and precedents covering the interim relief, in evidence, strategies, and key case laws. So to navigate a partition suit effectively, a solid understanding of legal framework is essential. So the acts which deal with partition suits are: number one, Code of Civil Procedure, which is a primary procedural guide. The key sections include sections 16 to 20 and 54 for the purposes of jurisdiction, Order 7, Rule 11 for rejection of the plaint, Order 8 for written statements, Order 20, Rule 18 for partition decrees, and Order 22 for death, marriage, and insolvency of parties. Order 26, Rule 9, 10, 13, 14 cover commissions, while Order 39 deals with injunctions, and Order 40 with receivers. And last but not the least, Section 151, which talks of inherent powers of the court. The other key statutes which will deal are Transfer of Property Act, TPA, and we would be paying attention to Section 44 concerning transferees of co-owners and Section 52 on list pendants. Then the other statute is Hindu Succession Act as amended in in the year 2005, more particularly Section 6, which is crucial for coparcenary rights, especially regarding daughters. Then Indian Evidence Act, which governs the admissibility of proofs of facts. Then registration and stamp laws, state-wise, and court fees and suits valuation acts state-wise. These are vital for compliance and valuation. Then we'll also look into Limitation Act 1963, particularly Articles 65 and 110, which are relevant for limitation periods in partition suits. Then Suits Valuation Act 1887, Sections 3 and 8, which guide us regarding valuation for jurisdiction. We'll also delve into frequently referred landmark decisions of the Honorable Supreme Court, such as Vinita Sharma versus Rakesh Sharma. This is a decision of 2020. Then Fulchand versus Gopal Lal. It's a decision of 1967. And Neelavati versus Natarajan, a decision of 1980. And other decisions which we will deal with in these slides, in the coming slides. So, determining the correct jurisdiction is a critical pre-filing step to avoid procedural challenges later on. For immovable property, Section 16 CPC mandates that suit must be filed where the property is situated. If the property spans multiple districts, if the property is in other districts or other local areas, then Section 17 CPC allows filing of the suit in any district where a part of the property is located. Section 20 of CPC deals with defendant's residence or cause of action, which is generally inapplicable for pure immovable property suits, which are governed by the specific provisions of Section 16 and 17 of the Code of Civil Procedure. For revenue-paying estates, Section 54 CPC stipulates that partition post-preliminary decree is to be effected by the collector. So, collector has the power to execute these decrees where revenue has to be paid on the estate levied by the government. So, Section 64 of CPC deals with revenue-paying estates. So far as pecuniary jurisdiction is concerned, this is determined by Suits Valuation Act 1887 and local notifications. The court fee valuation significantly impacts forum selection. Section 21 CPC deals with objections to the jurisdiction which must be raised at the earliest opportunity. If we are not raising this objection at the preliminary stage, then they would be deemed as waived. So this is a crucial procedural point which we have to take into account while defending the partition suit when we are contesting that the jurisdiction would not lie of the court where the partition suit is filed. Correctly assessing court fees and property valuation is paramount while filing the partition suits. So your pleadings would derive the court fees determination. If the plaintiff pleads joint or constructive possession of the property, a fixed fee applies. If it is pleaded that the property in question is jointly owned, then the fixed fee is applicable. This is governed by Article 17(6), Schedule 2 of the Court Fees Act or its state analogues. So Court Fees Act would be different for every state. So the provision would also be different in respective Court Fees Act. The landmark case of Neelavati versus Natarajan, reported in 1982 Supreme Court cases 247, along with numerous High Court decisions now, affirms that this fixed fee applies when joint possession is properly pleaded. So if you are pleading that the property in question is jointly possessed, then you will have to only pay a fixed fee that would be applicable as per the Court Fees Act. If the plaintiff admits being excluded or out of possession, that means you are not in the possession of the property and you are seeking possession, then an ad valorem fee is required. This fee is calculated on the market value of the plaintiff's share as per the applicable state act. If a particular property is of a value of 10 lakhs, then accordingly ad valorem fee would be applicable as per the court fees applicable in that particular state. It is crucial to draft the plaint carefully to reflect joint possession if it is factually accurate, as this directly impacts court fees liability. So, as I said that if the pleading says that the property in question is in joint possession and we are factually accurate about the same, then the court fees required to be paid would be less. So valuation for jurisdiction generally follows from Section 8 of Suits Valuation Act, and therefore always check state amendments and notifications for local variations, as these are significantly alter requirements, right? So there are various variations, also state amendments coming from time to time, notifications coming from time to time, which you need to see while calculating the court fees so far as the filing of partition suits are concerned. So understanding limitation period is also very vital for partition suits. The right to partition among co-owners or co-partners is continuous. So generally, the limitation begins to run only from a clear act of ouster or clear exclusion. Once one of the partners or co-owners or co-partners is excluded from the possession, then the limitation would apply from that period. Article 110 of the Limitation Act provides a 12-year limitation period for a person excluded from joint family property to enforce their share. So within 12 years, the co-owner or co-partner who's ousted or excluded from the property, the limitation provided under Article 110 is 12 years. Article 65 of the Limitation Act provides 12-year period for suits for possession based on title, which becomes relevant when defendant sets up a claim of adverse possession. The burden of proving ouster is substantially high. Ouster requires an open, hostile assertion against the co-owners. Mere exclusive possession by one co-owner is insufficient to establish ouster. So you have to plead, even though the co-owners are your relatives, you have to make an hostile assertion that you have been excluded from excluded from the possession of the property again against the other co-owners. So there is one decision which is reported in AIR 1957, Supreme Court 314, in the case of P. Lakshmi Reddy versus L. Lakshmi Reddy, is a decision which sets the standards for proving the ouster. So how to implead parties to the suit? Firstly, we have to correctly identify and implead parties, which is a fundamental for an effective and executable decree. The parties without whom no effective and complete adjudication can occur are the necessary parties. So who are the necessary parties? All co-owners or co-partners are necessary parties. Alienees of specific shares must also be impleaded. They are also necessary parties. Legal representatives of deceased parties need to be brought on record under Order 22 CPC. Whenever one of the co-partner or the owners passes away, then the alienees or the legal representatives need to be brought on record under Order 22 of Code of Civil Procedure. Now, what are proper parties? The proper parties are the parties whose presence is not strictly essential for the decree, but it is helpful for complete adjudication. So there are certain people against whom we are not seeking any direction of the court, but for complete adjudication, we have to make them parties. Why? Number one, a transferee pendent allied, that is, transfer during suit pendency, should be impleaded as a proper party. Such transferee are bound by the decree due to Section 52 of the Transfer of Property Act and Order 22, Rule 10, CPC. So, impleadment of parties, the guiding principle for this under Order 1, Rule 10.2 to add or strike parties is presence needed for effective and complete adjudication? So that is the test which is to be seen under Order 1, Rule 10.2, that who could be the parties made in the suit. Misjoinder or non-joinder of parties. Order 1, Rule 9, CPC states that misjoinder or non-joinder is generally not fatal. If you have accidentally made somebody as a party or you have not made somebody as a party, it is not fatal to your suit, but this exception does not apply to necessary parties. If the necessary party is not made as part of the suit, then omitting a necessary party can render the decree inexecutable. So, the case laws which are important for looking into as to who could be impleaded as a party are Vidur Impacts versus Tosh Apartments, Mumbai International versus Regency. This is the case of 2010, and Kasturi versus Ayya Perumal is of 2005, which provide guidance on impleading of parties in a partition suit. The 2005 amendment to the Hindu Succession Act marked a landmark change in the rights of daughters. So it provided equal rights to the daughters by birth. Section 6 of Hindu Succession Act, as amended in 2005, unequivocally states that a daughter is a co-partner by birth, possessing the same rights and liabilities as a son. The Supreme Court clarified in the case of Vinita Sharma versus Rakesh Sharma, which is a case of 2020, that the father need not be alive on 9/9/2005 for the daughter to acquire these rights. These rights are considered retroactive by birth, though they are subject to concluded partitions that occurred prior to the amendment. What are the evidentiary standards required for filing a suit by the daughters? The claims of oral partitions are now examined with heightened scrutiny. They are not ordinarily accepted unless proved by contemporaneous public documents or registered instruments. Then the law now demands unambiguous evidence of partition before 2005, creating a higher threshold for those claiming pre-amendment division. This is a crucial point which you need to keep it in mind, especially when such claims affect daughters' right. So the decision of Vinita Sharma versus Rakesh Sharma is reported in 2020 9 SEC page 1. So as we know that a well-drafted plaint is the foundation of successful partition suit. So firstly, what we need to consider is party and genealogy, which clearly show the relationships, family tree, ages, and addresses in a clear, easy to understand format. Then the title chain, which describes the nature of property, whether the property is ancestral or a self-acquired or merged into a joint pool. Also, you have to specify the date and time of alleged exclusion, if any, as this affects the limitation which I have discussed in the previous slides. Then we have to have property schedules which are very critical for clarity and execution. Schedule A, you have to list all the immovable properties. Then you have to have Schedule B, which would list all movable properties. Schedule C can give the detail of any encumbrances or tenancies. So you have to provide precise descriptions of the properties, their maps, khasra numbers, CTS, SROs details for each property. Any vague description can cause significant delays. So this is how you have to put it in a well-drafted plaint so far as the parties are concerned, title chain is concerned, property schedules are concerned. The legal elements include an avowment of joint possession if factually correct, because it would impact court fees. Then there needs to be a dedicated paragraph for valuation and court fees. If you're pleading a joint possession, you have to say that since it's a joint possession, the court fees is this much. If there is an exclusion or there if the property, if the suit, the pleadings are different, wherein ad valorem fees is required to be paid, then you have to correctly make a paragraph giving the correct valuation and the court fees. Then you have to see that your pleadings clearly state the jurisdiction and limitation aspects of the suit. And last but not the least, you have to make the prayers. So the prayers, the plaint should seek a preliminary decree declaring shares, consequential injunctions, and accounts or mean profits as per Order 20, Rule 12 of CPC. Then ensure the plaint is complete with proper verification and wakalatnama as per Order 7 CPC. So every plaint has to be properly verified, without which whatever is stated in the plaint would not be treated as correct. So proper verification is required. So here's a skeleton prayer for a partition plaint, which provides a clear roadmap for the court's direction. The plaintiff most respectfully prays that this honorable court may be pleased to pass a preliminary decree under Order 20 Rule 18 CPC declaring plaintiffs such and such share in Schedule A properties. So this is the first crucial step. Then the second prayer would be appoint a commissioner under Order 26, Rule 13 to 14 to effect partition by meets and bounds and submit a plan. This paves the way for physical division. Then on confirmation, pass a final decree and put plaintiff in a separate possession, which is the ultimate objective of your suit. Then last but not the least, grant mean profits under Order 20, Rule 12 from the date when the suit is filed or from any date when you are seeking grant of mean profit till the delivery of the possession, which means the compensation for loss of the use by the co-partners or other joint owners. Then restrain alienations under Order 39 Rule 1, 2 and or appoint receiver under Order 40 Rule 1. This is essential for interim protection because the property might change hands, it could be sold, it could be encumbered. So it is very important to have a restraint order under Order 39 Rule 1 and 2. Then last, award cost and further reliefs under Section 151 of the CPC. Securing interim protection at the earliest is very crucial to prevent the creation of third-party rights and for the preservation of the property. So, injunction under Order 39, Rule 1 and 2 is used to preserve the status quo and restrain alienation or creation of third-party interest in the property. Also, under Order 40, Rule 1 CPC, a receiver may be appointed where the property is in danger of waste or alienation or for the income if you're asking any mean profits out of the property. Then list pendants notice, while not an order of the court, Section 52 TPA dictates that transfers pendentialite are subservient to eventual decree. You can also pray list pendants to the court. There are certain courts who would pass an order that about list pendants that any transfer or alienation would be subject to the final outcome of the suit, right? But even if you have not pleaded, under Section 52 TPA dictates that the transfer, any transfer which takes place pendentialite, that is pending the suit, are subservient to eventual decree. It is advisable to consider lodging a caution with the sub-registrar's office, that is SRO, where available, to put potential transferees on notice. That is, you can put it on the record of the sub-registrar's office that the suit is pending before the court of law and is subject, any transfer is subject to the outcome of that suit. Then the appointment of local commissioner can be invaluable because they can conduct a site plan, assess the status of possession or structures, and gather information to support your interim relief applications. Because interim reliefs are always given by the court on the basis of whatever is produced before them. If you plead that your property is in danger, which is the property, then the local commissioner report, which is appointed by the court, can be very helpful because that defines the complexion of the property and information about what is the status of the property. So that would actually help the court to pass any injunction order or interim order if the report is clear and is placed before the court. The legal foundation of these protections lies in the Transfer of Property, Section 52, and CPC Orders 39 and 40, which I've already mentioned. So court commissioners play a pivotal role in partition suits, especially for physical division and investigation. The court commissioners are appointed by the court on payment of certain fees which might be shared by the parties. So what kind of commissions can the court order? One, local investigation under Order 26, Rule 9, CPC. It is typically for pre-preliminary decree purposes to ascertain facts on the ground. whatever you plead, the court can ascertain through a local commissioner's report or court commissioner's report as to what is the factual thing before the court which is being pleaded. This includes map or site plan creation, boundary identification, existing possession status, encroachments, market value assessment, and even mean profits assessment. So this can be ascertained by a commissioner appointed by the court. Then for partition implementation under Order 26, Rule 13 and 14 CPC, the court commissioner can be appointed after a preliminary decree. The commissioner's role here is to effect partition as per the declared shares. And then the court commissioner would submit a plan and suggest allotments. The terms of reference for the court commissioner must be drafted with precision, and they should cover the measurements and boundary identification, assessment of common areas, approaches, easements and utilities documentation, feasibility analysis for equal division versus ovalty money, that is the compensation for unequal division. So the commissioner reports constitutes evidence in this suit. Parties have the right to file objections to the report if they find that report says otherwise than the actual position. And the commissioner can be examined in the court under Order 26, Rule 10 of CPC. So Order 26, Rule 9, 10, 13 and 14 of CPC deals with the commissioner's report and the objections which parties can take on the production of the commissioner's report. So how to draft a local commissioner application? The essential amendments should include in an application for a local commissioner. You would start by making a statement that it is respectfully submitted that the subject properties require professional assessment to ascertain their true condition, boundaries, and current status of possession, which cannot be adequately established through documentary evidence alone. So this explains the necessity of why you want to appoint a local commissioner. The essential amendments should clearly state why on ground facts cannot be proved adequately by oral or documentary evidence alone. Then describe the properties requiring investigation with precision and specify excess requirements for the commissioner. Then ask for a scaled sketch with superimposed revenue map, town planning scheme. Then also request that all parties to be notified and allowed inspection access during the commissioner's visit. And then seek permission for photographs and GPS coordinates to be taken. Then suggest a reasonable timeline for report submission and offer to deposit the commissioner's fee. Also request for permission for technical assistance from a surveyor or the engineer if required. The prayer should contain that the subject property described in Schedule A lacks precise demarcation on ground. So the property cannot be demarcated on the basis of documents or any other evidence. Therefore, a local investigation is essential to elucidate boundaries, existing structures, and ingress-egress under Order 26, Rule 9. And the ultimate prayer you should be drafting is appoint a local commissioner with a licensed surveyor. One, to measure and map. Number two, superimpose revenue maps. Number three, note construction and possession. Number four, suggest convenient mode of division. And fifth, file a report with sketch within 30 days or whatever period according to the requirement and urgency. So the preliminary decree is a fundamental stage in a partition suit, though it is often misunderstood. The preliminary decree declares the shares of the parties without affecting physical division. So preliminary decree would only declare the share, and it does not talk about affecting physical division of the property. Physical division by metes and bounds comes later. However, in some cases, a composite decree can declare shares and effect division simultaneously, but this is less common for complex properties. So, first of all, a preliminary decree is made by the court, then a local commissioner or a court commissioner is appointed so that there can be a physical division can be affected according to the preliminary decree. So significantly, multiple preliminary decrees are permissible if supervening events occur, such as death of a party, changes in law, or other circumstances require adjustment of shares. So this flexibility is critical. So importantly, the shares can be reworked before the final decree. If there is an objection, if there is a court commissioner or a preliminary decree defining the shares, the final decree, the shares can be reworked. The rights of the parties remain somewhat in flux and can be adjusted until the final decree is passed. So what is the purpose of preliminary decree? The preliminary decree crystallizes the rights of the parties but leaves the actual division for subsequent proceedings. So this allows flexibility to accommodate changes until the final decree. The decisions on this point is number one, Fulchand versus Gopal Lal, reported in AIR 67 Supreme Court 1470, which is the case establishing the permissibility of multiple preliminary decrees. In the case of Ganduri Koteshwaramma versus Chakiri Yanadi, reported in 2011 9 SEC 788, also affirms the share modification before the final decree. The final decree brings the partition suit to its conclusive end, ensuring physical division and legal compliance. So after a preliminary decree, as I said, a commissioner is appointed under Order 26, Rule 1314 CPC. Their task is to execute the division of the property according to the shares declared in the preliminary decree. Once the commissioner submits its report, the court hears objections to the report, confirms the division plan, and allots specific parcels of property to the respective parties. So this is a critical step which is often overlooked. A final decree operating as an instrument of partition may require stamp duty, registration as per applicable state law. Neglecting this can create major hurdles for mutation and implementation. If you have not paid the stamp duty and you have not registered the property, So these are a couple of regulatory compliances which may create hurdle while you are mutating your property in the revenue records and for further implementation of partition. So this involves the delivery of possession of the allotted shares to the parties. It also necessitates mutation or revenue entries in official records to reflect the new ownership structure. And finally, it includes compliance with Section 54 of CPC where applicable, which means involving the collector for partition of revenue paying estates. So collector would be appointed wherein the estate has some revenue to be paid to the government. So first of all, the charge would be of the government to collect the revenue out of that property for which a collector is appointed. So CPC Order 26 Rule 1314, Order 20 Rule 18, CPC Section 54 and stamp registration laws are the crucial for passing of the final decree in a partition suit. So if you are defending a partition suit, you require to draft a written statement, and that is the opportunity to present your defense and counterclaims. So first of all, you must traverse specifically the allegations in the plaint. You have to clearly oppose the allegations. So you have to deny the allegations made in the plaint in respect of the suit as per Order 8, Rule 3(5) of CPC. Every allegation not specifically denied or stated to be not admitted is deemed admitted. Under Order 8, Rule 5, if you are not denying any allegation specifically, then it would be deemed admitted. Then you have to plead your positive case, such as there was a prior partition in status, separation in status, or an oral partition with full particulars. The relevant case for separation in status is the case of K. Raghavamma versus Chenchamamma, reported in AIR 1964, Supreme Court 136. Also, you must take preliminary objections. These can be crucial for an early dismissal or strategic advantage. The common objections that may include misjoinder or non-joinder of necessary parties, as I've already said in the previous slides, that if there is non-joinder of or misjoinder of necessary parties, it could be fatal to the partition suit. So you must plead that proper or necessary parties are not joined. Also plead undervaluation of the suit property or inadequate court fees paid by the plaintiff. Then you plead limitation, particularly of ouster or adverse possession. The other procedural requirements are consider filing counterclaims and set-offs where appropriate. We will discuss counterclaims in detail in other slides. Then you seek framing of issues or maintainability of the suit at the very early stage. You have to plead that the suit is not maintainable, or then immediately thereafter filing of the written statement, you have to plead the framing of issues. Ensure proper verification and affidavit as per Order 6, Rule 15(4) CPC, which is a must. the whatever is pleaded has to be on oath, clearly verified and notarized by there has to be a notary. The plaint or written statement has to be notarized by the notary. Then annex all relevant documents at the earliest opportunity. It applies to both the plaintiff and the defendant under Order 30 CPC. So what is a counterclaim? A counterclaim is governed under Order 8 Rule 6A CPC, which offers significant strategic advantages. So what is the scope and requirement of a counterclaim? Firstly, it allows any claim the defendant has against the plaintiff, provided it accrues before the defendant files their written statement. Next, a counterclaim is permissible even after the written statement has been filed, but before the framing of issues. However, this is also subject to the court's discretion and the absence of prejudice to the plaintiff. So, counterclaims are generally permitted even after the framing of the issues, depending on the facts and circumstances of the case. Like a plaint, a counterclaim requires a proper valuation and court fees payment. It is tried like a cross suit. If you have a counterclaim, it is a cross suit, meaning it is treated as an independent suit within the same proceedings. So the counterclaims offer several benefits. Number one, the relief can be granted even if the original suit is withdrawn or dismissed. Number two, it avoids multiplicity of proceedings, consolidating related disputes. Third, it provides a tactical advantage in negotiation. If there are counterclaims, you can always negotiate with the co-partners or the joint owners and gives the defendant an active claim. So, having a counterclaim is beneficial to the defendant to negotiate the claim made by the plaintiff. The case regarding the counterclaim, which is an authority, is Ashok Kumar Kalra versus Wing Commander Surendra Agnihotri, reported in 2019 to SEC, page 288. Which deals with the timing of counterclaims. So a counterclaim must maintain a connection to the original suit while satisfying all formal requirements of an independent suit. So whatever the plaint would have, counterclaim has to follow the same requirements as is being followed while filing the partition suit. Impleading of parties and understanding when and how to add, delete, or transpose parties, which is a very crucial part of partition suits. So, parties can be added or struck out under Order 1, Rule 10(2) CPC. The test is whether their presence is necessary or proper for complete adjudication of all issues in dispute. As I said earlier, if any party is necessary or proper, that cannot be deleted. But if they are necessary and proper, then they can be added. They must be added and they cannot be struck out because it is necessary. Their presence is necessary for proper and complete adjudication of all issues. Then transposition under Order 23, Rule 1A CPC, a defendant may be made a plaintiff or vice versa. This typically happens when original plaintiff withdraws or abandons their claim, but the transposed party wishes to pursue the suit. So this can be done if a partition suit is withdrawn for any reasons or is abandoned. Then the defendant who has filed a counterclaim can transpose himself as a plaintiff and the plaintiff as the defendant. Order 22 CPC governs the substitution in cases of death, marriage, or insolvency of a party. Order 22 Rule 10 specifically deals with transfers during pendency of a suit, that is, the assignment, creation, or devolution of interest, and timely application for substitution is necessary. Otherwise, your suit can abate. What are the guiding principles? The court generally applies two critical tests when considering the impleadment of party applications. Number one, avoiding multiplicity of proceedings, which of course promotes judicial efficiency. Then, protecting transferees' pendentolite interest without derailing trial progress. So this balances the rights of new parties with the need for expeditious resolution of the suit. So for partition suits, we need to have an evidence strategy, which is very essential to prove your case and rebut opposing claims. So the objective is to prove common title and quantum of shares of each co-owner, co-partner. Also, to rebut claims of exclusive title or adverse possession asserted by the defendant. And thirdly, establish joint possession where applicable, which impacts court fees and the overall narrative. Documentary evidence utilized various documents as corroborative evidence. Number one, the documentary evidence could be revenue records and municipal extracts, which would show the ownership and land details. Then, if the property is in a society, the society records and tax receipts, which indicate possession and payment of dues. Then, sanction plans and electricity bills can help establish de facto possession or usage. How can you prove or disprove ouster? Proving ouster is difficult and requires clear acts hostile to co-owners, that is, formal notice of exclusion, exclusive mutation in revenue records in one co-owner's name without the other's consent. Number three, unilateral rent collection without accounting to other co-owners. Prior litigation conduct demonstrating hostility. Here, the reference could be made to one case of P. Lakshmi Reddy versus L. Lakshmi Reddy, which sets out ouster principle, which I have already mentioned in my previous slide. Now, the other evidence is commissioner's evidence, commissioner's report. So what we have to be prepared to effectively cross-examine the commissioner on their measurements, findings, assess observations, and amenity allocations. If the physical division is unequal, we have to seek OLT, that is compensation, through the commissioner's report. So the Transfer of Property Act contains vital provisions impacting transfers involving co-owned property. So co-owner transfers are defined under Section 44 of the Transfer of Property Act, which says that a transferee from a co-owner steps into the shoes of the transferor and acquires their rights. This transferee can then seek partition of the property. The important exception here is if the transfer involves a dwelling house of an undivided family, an outsider transferee gets no right to joint possession, and such a transferee must sue for partition to claim their share. This provision protects family members from any intrusion of an outsider. Lis pendens is defined under Section 52 of the Transfer of Property Act. This doctrine states that transfers made during the pendency of any litigation are not void, but they remain subordinate to the eventual decree passed in the suit. The transferee becomes bound by the litigation outcome, while impleadment as a party is advisable to give them an opportunity to be heard, but it is not mandatory for decree to be binding on them. So Order 22, Rule 10 CPC essentially governs the procedure when there is an assignment, creation, or devolution of interest occurs during the pendency of the suit. Family settlements are generally favored by the courts, but oral partitions face stricter scrutiny, especially after 2005. So courts generally favor family settlements and apply minimal technical scrutiny if the arrangement is bona fide and voluntary. This is based on promoting family harmony. So nowadays, the provision for ADRs like mediation has been adopted by the courts so that there is an amicable settlement in the family disputes so far as the property is concerned. And therefore, generally, before deciding the case, there is also a pre-mediation sessions where the family members can sit and resolve their dispute in respect of the property, which is going to be adjudicated by the court in a partition suit. A document that itself creates or declares rights in immovable property ordinarily requires registration and stamp duty. However, a memorandum merely recording an already completed oral settlement may not require any registration. So this distinction is very crucial for all of us to understand. The landmark case on this is Kale versus Deputy Director of Consolidation, reported in 1976, 3 SSC, page 119, which is a precedent on family settlements. Post 2005 Hindu Succession Act, claims of oral partition are now examined with heightened scrutiny, particularly in the light of 2005 amendment to the Hindu Succession Act. If the family pleads that there is an oral partition, the shares were given, then the court scrutinizes it with a lot of introspectivity, where the scrutiny is very heightened. And the contemporaneous public documents are established to pre-amendment division. So it is the onus lies on the person who is claiming that there was an oral partition of the property before 2005. So somebody who pleads that has to prove it with contemporaneous public documents also. The courts are now increasingly demanding documentary evidence to support oral partitions, especially when such claims affect daughters' rights under the 2005 Hindu Succession Act amendment. And the ultimate outcome is the decision of the Honorable Supreme Court in Vinita Sharma versus Rakesh Sharma, reported in 2020, 9 SEC, page 1. So we also must be aware of common pitfalls which can save significant time and effort in partition litigation. One is undervaluation risk. So if your suit is undervalued, it can lead to rejection of the plaint under Order 7, Rule 11, B or C of Code of Civil Procedure. Then draft the court fee paragraph with precision and cite joint possession where factually accurate to avail fixed court fees. If it is a joint ownership property or there is a joint possession, then the court leviable is fixed and therefore you must draft it with precision. Missing necessary parties, this can result in an inexecutable decree. Also avoid meticulously audit the genealogy and all alienation transfers before filing the suit. Inadequate interim protection, that would create vulnerability to third-party rights being created during pendency of the suits. Always consider and apply for appropriate injunctions under Order 39 and Order 40 CPC or appointment of or consider appointment of receivers. Vague property description. If your description of the property is vague and not perfect, then it causes local commissioner report delays and there would be more objection, which would hinder the commissioner's ability to precisely identify and divide the property. So, provide detailed survey information and maps in the plaint and applications. Regulatory oversight, neglecting stamp or registration requirements on the final decree creates mutation and implementation problems. So be aware of and comply with state-specific stamp and registration laws. Quickly, we will have a look at the pre-filing checklist for practitioners. Client consultation and documents. Conduct a thorough client interview to gather all facts, document the genealogy meticulously, perform title scrutiny and complete encumbrance research to identify any prior charges or transfers, identify any pending related litigations concerning the property, how to collect the evidence, gather photographs and site sketches, obtain municipal and revenue extracts, crucially obtain valuation inputs from experts for court fees and pecuniary jurisdiction assessment, then determine the appropriate forum based on valuation, formulate a clear strategy for interim relief and local commissioner application, and draft the plaint with clear property schedules, calculate accurate court fees, and prepare supporting evidence, affidavits, and wakalatnamas. So, partition litigation is a marathon. That means it takes a lot of time. It is not that this litigation would be decided in a jiffy. It would take a lot of time and like what a marathon takes. So, careful attention to each and every procedural stage is essential for a successful outcome. So preliminary phase is for practitioner have an early preliminary decree declaring shares. This crystallizes the rights of the parties. Then ensure precise framing of issues covering ownership, shares, ouster, alienation, and mean profits. Then move for local commissioner with comprehensive terms of reference. That is, a detailed terms of reference ensures the commissioner gathers all necessary information for fair division. Then file timely, detailed objections to commissioner's report if necessary, because this is your chance to challenge any inaccuracies on unfair proposals. Then final phase is seek OLT, that is compensation or sale, if the property is practically indivisible by metes and bounds. Then you can ensure final decree compliance with registration requirements. And last but not the least, follow through the stamp duty payment, registration, and mutation in revenue records, because this final step ensures the new ownership structure which is legally recognized and enforceable. Now, we'll have a look at the case laws. Neelavati versus Natarajan. The Supreme Court in this case, the Supreme Court affirmed that a fixed court fee applies when joint possession is pleaded, and plain averments govern court fees determination. In P. Lakshmi Reddy versus L. Lakshmi Reddy established a stringent standards for proving ouster among co-heirs, stating that mere exclusive possession is insufficient. So you have to plead by hostile averments that there was an exclusion from the possession of the property. Then, in the case of Fulchand and Gopal Lal, the Supreme Court clarified that multiple preliminary decrees are permissible to accommodate supervening events during the suit. In Gandhuri Koteshwaramma versus Chakiri Yanadi, the Supreme Court confirmed that share modification is allowed before the final decree and affirmed daughters' rights under the amended Hindu Succession Act. Then in Vinita Sharma versus Rakesh Sharma, which is a landmark judgment, ruled that daughters are co-partners by birth and established a higher scrutiny standard for alleged oral partitions, especially those claiming pre-2005 division. The other decisions are Vidur Impex and Mumbai International Airport, which are guiding cases on Order 1, Rule 10 principles for adding or deleting parties. Ashok Kumar Kalra clarified the timing for filing a counterclaim. Kale versus Deputy Director, a foundational case on family settlements jurisprudence. To solidify our understanding, let's briefly consider some discussion scenarios that often arise in a partition suits. These are designed to stimulate thought and application of the principles we have already covered in the previous slides. One is contested possession. The plaintiff pleads joint possession, but the defendant sets up an oral partition from 1998 presenting exclusive tax receipts as evidence. So this scenario brings us the burden of proof allocation, the evidentiary threshold for oral partition, and the weight of tax documents as proof of possession versus ouster. Then pendentolite transfer, pendentolite transfer. A transferee pendentolite seeks intervention at the final decree stage, having remained uninvolved earlier. So we would examine the scope of their partition rights, limitations on challenging earlier findings, and the procedural requirements for their impleadment at a late stage. Then dwelling house rights. An outsider purchaser of a dwelling house share attempts self-help by breaking lock to gain entry. Now, this highlights the application of proviso to Section 44 of Transfer of Property Act, wherein the remedy is available for family members and potential criminal and civil liability implication for the outsider. Administrative coordination. Agricultural land partition requires coordination between the civil court, decree, and revenue authorities. So this scenario focuses on the procedural interface with Section 54, where there is a provision for collector's role, ensuring consistent implementation of the decree and the jurisdictional boundaries between civil courts and revenue authorities. So to conclude, let's summarize the strategic principles for a successful partition litigation. Draft, plead facts to support the court fees you intend to pay and legal narrative you wish to present. Push for a precise preliminary decree and a detailed local commissioner terms of reference, because these are foundational for clarity and effective execution. Then secure interim protection at the earliest. Anticipate necessary impediments to safeguard the property and your client's interest. Then maintain a comprehensive final decree. Ensure all post-decree compliances are met. And remember, partition litigation is a marathon and not a sprint. Strategic foresight, procedural discipline, and attention to detail are the hallmarks of successful property litigators. Thank you very much.
Sir, if participants have some questions, will it be okay if they're addressed?
Yes, but you see, you can just put it on the chat also so that I can clearly identify.
Participants, those who have questions, kindly put it in the chat.
So there is one question, how the valuation of property in a supplementary deed of the partition deed is done. The valuation is done by the state notifications. Please give access to speak. I guess you put the questions.
Sir, if it is okay, then I can allow them to unmute and ask a question.
Please do that.
Sure, sir.
Hi, sir.
I
Sir, we have filed an injunction suit and we have got a stay restraining the defendants from pursuing further construction in that particular suit scheduled property. Okay, the defendant and the plaintiff both are brothers. they have other family properties still on, which they have inherited and all that. The second brother, who's the defendant, is like quite notorious. I mean, it's politically connected and all that. Now, in the same suit schedule, in the OS, in the same OS, can we file an injunction restraining the second brother from alienating those properties in the same suit?
In the same suit, you see, whenever you're filing a suit, the prayers are specified in respect to the properties. So you cannot file it in the same suit. You will have to move a separate, because this is not a partition suit you're talking about. You have filed a suit for injunction, right?
Yeah,
So,
yeah.
in the suit of injunction, you are injuncting somebody from or restraining somebody in respect to a particular property. So you will necessarily have to amend the plaint if at all you are wanting more injunction. But you cannot do it because you will have to then file a substantive suit for injuncting a different property. As you say, if there are other properties, necessarily there has to be a separate suit which is of injunction, because this is not related to partition at all. So the complexion of the suit would be where the property would be defined and you would seek injunctions by pleading as to how you are being affected, how your interest is being affected, and how there is a likelihood of any alienation or transfer of that property.
Okay, sir. In that case, I'll file another suit for injunction. And can we request the court to club both the matters and be heard together?
Definitely, you see, depending on if the court wants to avoid multiplicity of proceedings, it is always advisable you can plead before the court that club the matters together. That can always be pleaded, but it depends on the discretion of the court looking to what is the pleadings as to whether they are connected. So ultimately, this is always beneficial to club the suits where the parties are same or the property is related. So you can always request the court for clubbing of the suits.
Thank you, sir.
Thank you. Two son's daughter has been money at the time. So there is a question which says that there are two sons and a daughter. Daughter has been given money, I suppose that at the time of division of the property, but after 15, 17 years, daughter filed a case in court and got named in the property jointly. Now property is jointly named in the name of two sons and a daughter. Now, how to get partition if one son is not willing to give property? See, you have to first of all tell me as to what is the partition. If there is a partition, if the name is, you have to file a partition suit if you want the partition of the property. You have become, by the case the daughter which the daughter has filed, you have become the joint owner. Now, when it comes to the partition of that property, you have to file a partition suit, as has been explained by me, how the partition suit can be filed, and you can request the court to divide the property. So that is how you will have to file a suit and plead accordingly that you need to have your own share in the property, which would essentially require you to plead uh, the segregation of the property, the appointment of local commissioners, have a preliminary decree, and the final decree ultimately. Do we have filed under Section 34? Now, there is a question, if in partition suit, one legal heir is not included, will lead to dismissal under Order 7. Yes, under Section 11 of CPC, which deals with rejection of plaint, the plaint shall be rejected in the following cases. Number A, where it does not disclose a cause of action. B, where the relief claimed is undervalued and the plaintiff, on being required by the court to correct the valuation within a time fixed by the court, fails to do so. C, where the relief claimed is properly valued, but the plaint is written upon paper insufficiently stamped, and the plaintiff, on being required by the court to supply the requisite stamp paper within a time to be fixed by the court, fails to do so. Where the suit appears from the statement in the plaint to be barred by any law, where the plaintiff fails to comply with it, provided that the time fixed for the court, the correct valuation. So this under order, this is about partition. Okay, do we have file under Section 34 of this specific relief act along with Hindu section for Hindu daughter right of claim to be to her deceased father ancestral property? Do we have to file under Section 34? Not necessary. There is a question, do we have to file under Section 34 of Specific Relief Act along with Hindu Succession Act for Hindu daughter right or claim to her deceased father ancestral property? The partition should be enough to decide the claim of the Hindu daughter under the amended Hindu Succession Act 2005. So you need not file any other suit under Section 34 of Specific Relief Act. Are there any questions, or shall we close this session? All right, thank you very much. And I hope I've been able to throw light on how this partition suits are to be filed before the court of law. What are the intricacies involved? What are the strategies you can bring in while filing the suit? What are the essential requirements for filing the partition suit and defending it effectively before the court of law? Thank you very much.
Sir, I sincerely thank you for today's session, today's insightful session. The way you explained the subject with such clarity and practical perspective has given us a deep understanding and much to reflect upon. Legal Expatriate is really grateful for your time and efforts. Thank you once again.